You all good?
Let's go for it.
Well, good afternoon. Thank you for being here. Man, what a great turnout. Thank you so much. We did run out of handouts, but Michelle, who is always our angel of mercy and goodness, is going to go make copies during the talk. So, after, if you didn't get the handouts, we'll have some more for you to pick up. And so, it is my pleasure to introduce Leanne Cassis from Wyatt Early Harris Wheeler. Did I get that right?
You did.
Yay. And she is a local attorney and has been a great resource for us and many of our residents. And so the topic today came at your request. Many residents asked for information on this particular topic. So she is going to speak and share information, and then I think she is going to do questions at the end. And when we do that, we'll do what we typically do, have you raise your hand so I can bring you a microphone so everybody can hear it. We are attempting to record so that we can put this on CareMerge. So without further ado, I give you Leanne Cassis. Y'all give her a warm welcome.
Well, I will say this: you certainly know how to make a girl feel loved, or at least appreciated. So it's great to see so many people here. I'm always happy to talk about things and try to demystify the process because there's a lot of things that go on in the legal world that when you're trying to figure out how it applies to your actual situation, there's so much information out there that it can really just blow your mind. And I'm glad to help try to give information. And hopefully today I'm not going to give too much because I don't want to blow your mind today. But I do want to give information and then at the end let you ask some questions. If I need to clarify things or you have more specific questions, by all means, I'm always happy to answer those questions. The other thing is today's topic is to be what happens after a loved one dies. What are things that we need to know? And as I've been here getting things set up, I've had a lot of folks come and ask me questions that aren't necessarily on that topic, but are excellent questions in and of themselves. So, what I'm going to do is I'm going to keep the presentation on topic, if you will. But towards the end, I'm going to address some of those questions that were asked to me at the beginning of this afternoon. And honestly, keep your questions to whatever you want them to be. I'm here for you. And so you just let me know what you need to know. And so, but let's start. Let's talk about what's honestly sometimes the worst time in anybody's life is when you lose somebody. And even if it's been, a long time or time coming, it's never going to be an easy time. It's going to be hard. And so when we talk about what are the first things that, yes, ma'am. Oh, I can. You don't know what you've gotten yourself into, but yes, I'm glad to do that. Can you hear me better? Okay, excellent. All right, here we go. Folks in the front row, good luck and Godspeed. All right. So, when your loved one dies, that's a hard time. And you're going to be dealing with a lot of different emotions and dealing with a lot of paperwork and questions and all sorts of things. All of that is going to be important, and you're going to need to take action in due course. The first thing that I want you to do is breathe and take time for yourself. Take time to grieve, take time to get your wits about yourself the best that you can. There is very little that has to be done in the immediate moments after someone passes away that you absolutely have to step to and get done. Okay? So, the first thing you need to do is take time for yourself. Then, within, as soon as possible, as you're going to do, you're going to let folks know. You're going to let family members know, friends, coworkers, other important folks in your life and that person's life, let them know. And you're also going to, of the things that you do want to go ahead and get looking into, is to make sure that if there's been any funeral or burial plans that have been made. And because those questions are going to come pretty fast. Okay. So that's good to look for that first. If possible, it's good to have, not fun to have, but good to have those conversations beforehand because those kinds of things do need to be taken care of pretty quickly. And get those and to get that process moving towards the celebration and recognition of that person's life. Then you start to move into more of the paperwork side of things. You're going to start making those arrangements for burial, for cremation, interment. If someone was a veteran, you likely want to contact the VA. See if they've already made arrangements with the VA, or talk to them about what kind of arrangements can be made, or if you want to have someone to have a military presence at that person's services, you may want to do that. The VA is always good about taking care of their own and giving them the recognition they so greatly deserve. You also want to go ahead and start kind of getting your arms around things. You're going to want to secure their property, arrange for pickup of their mail. If they have pets, arrange for care for those pets. And then time goes on, then we start to get into the thick of it. And that is the actual administration and getting about the business, unfortunately, after someone dies. So, a couple of things that you're going to do. One, you're going to want to get the death certificates. Those were usually obtained from the funeral home. They're going to ask you how many you want. 5 to 10 is usually plenty. I know sometimes folks say, I have no idea. I got 20. Well, you know what? So be it. But usually 5 to 10 death certificates will do you just fine. Um, Also, along the gathering to get the business started, is you're going to want to locate the original will. That's important. The There's lots of things in life, especially now, that we can do with copies or with something that was sent electronically. When it comes to the estate world, we are still dealing with paper. We are still dealing with originals. So the important thing is to find the original will. Usually, it is, if it's prepared by attorney, it's usually going to have a backing to it. Usually it's on maybe heavier bond paper. I actually have my folks sign in blue because it's easier to tell blue versus black, what's the original. But try to find that original will. We can probate a copy. It is possible, but one, it's not always successful, and two, it's a lot more work that you'd rather not have to go through. So I would say try to find that original will. As part of that is you're going to have to locate the executor. Now, that may be you. If your spouse, typically it is you, or it may be a child or a dear friend. But they need to know that they're up to the plate. They are going to be serving as executor of the will. Other folks you want to contact is if that person had an accountant. It's good to get in touch with that person. Why? Well, as time goes on, one, they need to know that person has passed. They're going to be able to give you some really good information. But you're also going to need to know whether or not there's a final, hello, and whether or not there's a final income tax return that needs to be filed. You may need to go ahead and get them at the ready in case there needs to be an estate income tax or an estate tax. That's actually pretty rare these days, tax return filed. And the other thing, and we're going to talk about this more in a little bit, but tax returns, if you're sitting there saying, I have absolutely no idea what this person had, a tax return is a great place to start putting together clues as to where assets were. So getting in touch with that accountant, can be a really great resource for you, as well as a great advisor for you going through the process. The other thing is that you don't have to, but you may very well want to contact someone like me, an estate attorney. Can you handle probate by yourself? Is it legal to absolutely it is. It's certainly legal to handle it by yourself. But folks like us are used to doing it. We do it all the time, and we can a lot of times get it focused down to what actually needs to be done. I will tell you, and I love our clerk's office, and so I'm not saying anything bad about them. It's just what they're under their rules that they have to do. When you go to the clerk's office, they're not going to be able to give you advice. And that comes down from above to them, that they're not allowed to give you advice. They can give you a packet to give you options, and then they will let you turn to the kiosk next to them and let you start filing through the computer. That may or may not be a comfortable thing for you. So anytime that you want to contact someone like me, that can be very helpful to at least kind of either get you started or guide you through the entire process. And then initially, we're going again, there's other kind of steps to this, but you do probably want to go ahead and start identifying whether or not there's open credit cards. We want to start minimizing fraud and things like that pretty early on. So let's identify if there's credit cards that need to be closed, if there's utilities that don't need to be used, that we need to get those cut off. Some things with like the lights in a house, we probably want to leave on. But cable, things like that, you probably want to go ahead and stop those services and stop having to make those payments. Email accounts, social media accounts, those kinds of things, you likely want to go ahead and start closing down. So those are your kind of initial steps of kind of, I'm in this morass of someone's passed, what do I do? Those are the kinds of things that will get you started. It'll get you off of that, I don't know where to start kind of thing, and let you start moving, start gathering some information. Now, the next thing, what people love to deal with, and I am totally kidding, is probate. Now, I will say this. Probate is not the big, horrible, nasty that a lot of folks fear. There's a lot of detail to it. There's a lot of work to it, but it doesn't all have to be done at once, and there's steps to it, okay? So it's a process, but let's talk today a little bit about, like I said, let's demystify that process a little bit and see that it's actually just a lot of just steps. Nothing grandiose, but just a lot of steps. I'm not going to spend a ton of time on the different kinds of probate filings. This is not a continuing legal ed course, so I don't think y'all came here for that. I'm going to focus more on what was the common administration, and that's full administration. Just so you do know, there are some other more simple kinds of forms of probate. One is a small estate, literally a small estate. It has to be less than $30,000 for a spouse who is a sole heir, or less than $20,000 if it's multiple beneficiaries. Small estate is not effective to pass real estate. Is an option. I will tell you very often, we find that the small estate, even though we think it might work at first, we end up doing a full administration. And honestly, it doesn't cost that much more money. It really, truly does not. It's a couple of $100 difference in filings with the court. And it gives you more options. It gives you more leverage. It gives you more voice as an executor or administrator. There is something called a summary administration. This is for a spouse when it's just a surviving spouse and they're the sole heir and they're saying they're going to assume all liabilities for that person's debts. That can be a risky thing to say because, depending upon what those debts may be, depending upon what medical bills they may have had, things like that, It's an option, and we can certainly talk about it, but it's not without its own perils. The other thing is what's called a spousal years allowance. Now, this is not necessarily its own kind of probate. It's something that oftentimes we do in conjunction with. What is a spousal years allowance? So let's kind of start to dig into some of the weeds. We're going to talk about spousal years allowance, and then we're going to get into probate. Spousal years allowance. This is when there's a surviving spouse and there's a few assets of personal property that we want to move to that surviving spouse. So, what does a year's allowance move to that surviving spouse? Well, first of all, is personal property. We can't move real property, we can't move land, buildings with a year's allowance. But what can we move? Bank accounts, a car, personal property. That's like I said, that's your bank accounts, that's vehicles, that's stuff. What a spousal years allowance does is it says, as a surviving spouse, you are entitled to the first $60,000 of your spouse's estate, free and clear of any and all creditors. So you don't have to worry about, well, wait a second, there's this debt that needs to be paid, that debt. That doesn't apply to that first 60,000. That goes to you as a surviving spouse. When do we use this? A lot. A lot of times when the first spouse dies, honestly, we often only do a spousal years allowance. We're talking a little bit about how assets flow, but a lot of times between spouses, you own assets together as a married couple, joint with survivorship. So when one dies, you show a death certificate goes to the other. Or it has a beneficiary designated. Life insurance, retirement plans, all those kinds of things usually have a beneficiary. So a lot of times when the first spouse dies, there's very little to do because either you're going to get it as the surviving owner of an account or you'll get it as a beneficiary. But oftentimes we'll find that there may be a little bit of something. There may be that Mad Money account that has $5,000 in a local bank. There could be a car. There could be different little kind of cleanup things. And that with that year's allowance, we simply list them on the filing with the court, file it, court approves it, gives that very document back to you, and then all you have to do is take that document, a death certificate, and then go and get that asset. So if you can take the death certificate, the year's allowance, go to the bank, close down that $5,000 bank account. Year's allowance, death certificate, title to the vehicle. Now, this is not a fun day, but just pack a lunch. Go to the license agency and sit down, and then you can move the car over to you. So we use that spousal allowance a lot because it honestly may be the only thing that we have to do. Or sometimes we do it in conjunction with some other things. Sometimes there is real property or other things, but we want to go ahead and get just some things moved more quickly. We can use that year's allowance. So we've got some tools available to us. Now, let's talk about administration of an estate. When I do that, I'm going to get into a lot of different things, so I go ahead and give you fair warning. But if you have questions, let me know. So the full administration of an estate. First of all, how does it start? It starts with filing an application for probate with the clerk's office. And as I alluded to earlier, Guilford County and many surrounding counties and ultimately all of North Carolina will be doing what's called e-filing. Back in the day, and I say back in the day, I mean like a year and a half ago, you could go to the clerk's office take your will, they would give you some paperwork, you'd fill it out across the desk, hand it back, and they'd process it for you. That's not where we are anymore. Like I mentioned before, now it's thank you so much for coming to see us today. There's the kiosk, and they're going to have you type things into the computer, scan things into the computer. It's different. It's supposedly more convenient on their side. We're a year and a half into it. It's gotten a lot better, and I think we'll get better. But right now, admittedly, it's still we're still getting our sea legs to us. And if you're not used to it, it can be a daunting task. And I'll just go ahead and I'll just say that. Well, that or if you went to see an attorney, we would file it separately. We have our own logins that we can do it from our desk. This would be if you're handling on your own. But you file an application that starts probate. Now, there's a lot of different ones. I'm not going to get too lost in the weeds, but I'm going to focus on two key ways that it moves forward. One is with a will. The other with a will. And then the other is without a will. Okay? If there is a will, and you'll hear testate or intestate. Testate simply means there's a will. Intestate means there isn't a will. With a will, you're going to file that will, a death certificate, and that opening application that gives who the person is serving as the executor, who are the beneficiaries, and a very summary listing of assets. Very summary listing of assets. Basically, we're saying, hey, clerk, there's something we need to do here. You're probably not going to have all the information. The court doesn't expect you to have all the information, but you're going to say, I know that there's a bank account. I know there's a car, something like that. And you're going to list it on that application. Now that's for if there is a will. You're going to list the beneficiaries under the will, the executor named under the will. What if there's not a will? What do we do now? First thing, the assets do not go to the state. They do not. I don't know at what point that got out there, but take that thought right out of your brain. The assets do not go to the state. What does happen, however, is that the state, through our own statutes, says who does get those assets. And there's a statutory listing of how assets flow, in what order, and who can serve as administrator of the estate and in what order. Administrator is the same thing as an executor. It's the same role. It's just the administrator is designated when there's not a will, an executor is designated when there is a will. It's just a terminology difference. So if there's not a will, then we're going to look to see if there's a surviving spouse who can serve as executor. They're the ones who stand in that first position. If not, are there kids? Now, all the kids are going to sit on the same line. If you've got 5 kids, they probably don't all 5 want to serve as administrator together, and I would really recommend against that because that's going to be a mess. But they all stand on the same level to serve, and there's listings of who can serve, and then there's also a listing of who inherits, and it is different. So just to be clear, if there's not a will, things don't automatically all go to the spouse. If there are no children and there is a spouse, then yes, it will all go to the spouse. But if you have children, if the decedent had children, then depending upon how many children there are, those assets are going to be divided between the spouse and children. So that's something that you need to know, because it would be natural to think, well, I was the spouse, so surely I inherit everything from my deceased spouse. Not necessarily the case, okay? So you're going to go in, you're going to get either an attorney to help you, or you're going to be brave and go into the courthouse and get it done. You're going to get the probate process started by making that initial filing of that application. You file that application, you swear an oath saying you're going to do everything in accordance with the law, and you get kicked off on probate. Now, what happens next? A couple of other things. One, court's going to take those documents, and they're going to then officially appoint the executor or the administrator of the estate. Okay? So even though somebody's designated in the will and it says, I want Mary Smith to be my executor, Mary Smith is not technically your executor yet until Mary Smith goes and gets appointed by the court as executor. So again, things that people think, again, if you don't do this every day, it would kind of make sense. Says I'm executor. Here I am. Unfortunately, the court's going to actually have to appoint you. Bless you. And so when they do, you're going to get what's called letters testamentary. That's when there's a will. Letters appointing an executor under a last will and testament, or letters of administration, appointing an administrator when there's not a will. Again, same role, different titles. But that document, that's your key to the kingdom. Until this point, you have likely not been able to talk to a bank. You've gotten I can't talk to you. They can't talk to a bank or a financial institution. You try to go sell the car. You can't do anything with that. When you get those letters, now you have that ability. Now people are going to talk to you because the court has blessed you with serving in this role. So you get your letters, and once you're appointed, the other thing that you're going to want to do is to start a notice to creditors. That gets run in the local, it has to be a local paper of general jurisdiction, general distribution, also called the Jamestown News. So, no offense to High Point Enterprise. If anybody here worked for the High Point Enterprise or has youngins who work there, whatever, they're wonderful. They just charge more. So if you open up the Jamestown News or the Denton Order or all sorts of these other smaller papers, and you open them up and they're nothing but legal notices, that's why. It's because they charge less but it meets the statutory requirements. Because what that's doing is it's giving notice, saying if there are any creditors of this decedent out there, you've got 90 days and the clock is ticking to say, hey, I have a claim against this person's estate. And so they've got 90 days to file that with the court to say they have a claim against the estate. Day 91, no joy. They no longer have that claim. Now, and that's great because what it does is it shuts down this universe of creditors. Now, what it doesn't do is, let's say that you know that this person went to Cone Hospital and they had surgery, or they were over at Baptist, or they were wherever else. There was some known creditor, known medical debt, known credit card, known debts. If you know about them, you know about them, and you can't say in the case, for example, of a hospital bill, well, it came beyond 90 days, you're out. Because I promise you that bill will come more than 90 days. It just takes longer, takes a while to go through insurance, all of that good stuff. When they send that bill, it's going to be a valid bill. That's going to need to be paid. But a lot of what this does is it shuts down the ones, and unfortunately we see folks, they say, oh, well, I came out and I worked on their windows, or I worked on that front door, or I did. It shuts down a lot of that kind of mess, so that we then know at the end of 90 days who our valid creditors are. And by the way, if you get a claim and you're serving as executor or administrator, and you look at it and you say, that doesn't look right, that doesn't sound right, I'm not sure about this, then you don't have to just accept it. If you need to challenge it, challenge it. If you look at it and you say, absolutely no way, then you can always deny a claim, and then it's back on them to prove up that it's a valid claim. Okay? So we've got a 90-day, we've gotten you appointed. We've got a 90-day notice to creditors period that's running. So now what are we doing? Now we're trying to figure out, what are we dealing with? So let's talk about the assets that run through probate, the ones that we're going to have to handle during this process. So let's start with the basics. Bank accounts, checking, savings, money market, CDs, your basic everyday bank accounts. Now, those accounts can be held in all sorts of different ways. They may be held just by an individual, just in their name, that's all, nothing else. If there's an asset, a bank account, CD, etc., that's held just in that person's name, there's no beneficiary, there's no joint owner, then that kind of account is going to go through probate. Talk about more what that keeps meaning, but we'll just put that in your head. That's what we're talking about. Now, let's say there is a bank account or checking account that's held jointly. For example, with a spouse or with a child. That's held jointly with survivorship. Then, when you have an account like that, you'll simply take the, again, death certificate, and the person who is that joint owner would then be entitled to have that asset moved to them outside of probate, okay? If it's an account that maybe is made payable on death or transfer on death, POD, TOD, then same thing. Then that account, you would go show a death certificate and it would pay out to that transfer on death, payable on death beneficiary. That would not go immediately through probate. Likewise with investment accounts, regular old brokerage accounts or IRAs, 401ks, if those accounts are simply held in that person's sole name, no joint owner, no beneficiary, as I tell my clients, it has nowhere else to go, then that's going to be controlled by probate. But again, if there's a joint owner or if there's a beneficiary, then that's going to be filing that claim with that financial institution, and that's going to move out to those individuals. Now, I want to caution you here with one thing. I was debating when I was going to say this. One thing that I see happens a lot, and I get it. I get why folks do it. I totally understand it. But I want to caution you about it. Is because what I just said, well, doesn't it sound easier? Shouldn't I just go and put somebody on as a joint owner on all of my accounts? Be careful about that. It may just be the right answer. Not telling you it may not be the right answer. But be mindful of that. Because in the case of a spouse, that's probably pretty easy. Yeah, go ahead, have your spouse on that, and then that makes it easier. When they pass, they can just show a death certificate, it moves to them. But where can that not be a good idea, or where can it create problems down the line? Let's say you've got 2 or more children. And let's say maybe your spouse has already passed. Or maybe they haven't, but maybe your dear daughter Julie is just your right-hand girl, and she's been wonderful. She's the one who handles everything for you. She goes and helps you with things. Well, gosh, shouldn't I just go ahead and put Julie on my account? Wouldn't that make things easier? Well, you got to be careful because, one, you've just taken an account that's yours, and now you've made it belonging to somebody else. I'm not casting aspersions on Julie, but now that money is deemed hers as well. if she were to get sued, if she were to get divorced, if she were to get things were to happen to Julie's life, then now that gets spun up into her life. So be careful about that. I've seen things happen. Also, let's say nothing happens. Let's say it's just fine. But then you pass away and it goes to Julie because she was the joint owner on the account. But you also have your son Jimmy and you've got your son Johnny. And they're going, why is Julie getting all the money? Well, because she was the joint owner on that account. And so sometimes you may unintentionally disinherit somebody when all you were trying to do was make it easier just for her to handle your money, pay your bills, and do those things. Again, I've seen it. And, worst case scenario, Julie says, forget you two. It's coming to me, and Jimmy and Johnny are out of luck. Even in a best case scenario, let's say that Julie says, I know this is not what they meant. I'm going to cut you back in on this account. Well, if it's a few $100, few $1,000s, maybe that's no big deal. But if we're talking about something that's pretty sizable, like a brokerage account, something that may have hundreds of thousands of dollars in it, then you're potentially creating a taxable event for Julie. Because if she says, well, I'm going to go back and give it to my siblings, then, they may need to file a gift tax return. She may have to do some other stuff. So we'll talk about this maybe towards the end. Just a little note, probably the better thing to do is have a power of attorney. And if you want to name Julie as your power of attorney, let her have that role. And then she can go use that money, pay your bills, do all those kinds of things. So you've got your assets that are in just that person's sole name. Those are going to come into the estate. You have ones that have joint owners. They've got beneficiaries. They're going to pass out to them. So you're talking about bank accounts, retirement accounts. You've got your household items that are going to come through. You're also going to be dealing with a car. Something just as a good thing to note about cars. Lots of times, those cars are just in that decedent's name. So I can't tell you the times we've been checklists, we're great. This has got a beneficiary, this has got a joint owner, we're doing well, and there's a car. So now we got to do something with it. So those are usually just in that decedent's name. So you're going to probably have to do a little something with a car. Kind of something to think about, little tip, especially if you are a married couple who a lot of folks do, they jointly own their vehicle. Take that title. First of all, look at it. If it just says your name and your spouse's name, for example, that means that you own one half of the car and your spouse owns one half of the car, and ne'er the twain shall meet. So that if spouse dies, then half of the car is going to have to go through probate. Right? What they don't tell you, I don't think, when you're buying cars or getting your title, is that there's a nice, easy way to handle that. And that is if on the face of the title, and it has to be on the face of the title, it says Mary Smith and Joe Smith, and to the right, it either says joint tenants with rights of survivorship, or the initials JTWROS or JROS, or I've seen variations on it. It works. In that case, what you've done is you've taken that and you've made it with survivorship. So then all you have to do is take that title, that death certificate, a lunch to the DMV, and then you'll transfer that car to you without it having to go through probate. Okay? So once you get in all of those assets that are they have nowhere else to go, and they're in. So you've closed out a bank account, you've opened up an estate account or an estate brokerage account. You've identified all of those assets that are part of the estate. And then you've identified all of those final debts of the estate. Then, once you know, and I advise folks, hold tight. I know folks are good. They want to pay their debt, and they don't want that person to, they always pay their bills. I'm not going to not pay their bills. Well, you will. You're going to pay their bills. But there's an order to making those payments. And so we want to be careful about it. So once we know the assets in the estate, and once we know the debts of the estate, then we're going to set about paying those debts with those estate assets. Now let's be clear. The debts of a decedent are their debts. They are not the executor's debts. They are not the administrator's debts. They're not their ne'er-do-well child who never did a daggone thing, so why won't you just go pay this bill? They don't belong to anybody else but the decedent, okay? So it's just their assets that are going to be needed to pay those claims. Your executor's not going to have to come out of pocket to do it, okay? But that's why we want to know what we have to pay them with. And there is an order to payment. I'm getting a little in the weeds here, but the rough part of it is cost of administration, attorney, court costs. Those get paid off the top. The first $3,500 of funeral, first $1,500 of burial, off the top. Then, shocker, comes IRS. Then Department of Revenue. Then municipal taxes, local taxes, property taxes. Then if they owe outstanding wages, etc., medical bills, and then we filter through, and then we get to the bottom, those ninth class creditors, and those are everybody. That's your credit cards, that's what you owe to Bob, that's what you owe, all of your other stuff. And so what you have to do is you take those assets and you pay those bills and you clear them out at each level. Because here's the thing, let's say this money runs out on level 6. Then that's okay. We pay off level 6 pro rata, and we tell everybody else beneath them, money ran out. And that's okay. Then they're used to it. That happens. And all they can do is write it off. The only time you're going to get in trouble as an executor administrator is if you go and pay a ninth class creditor, and you run out of money, and then, oh, you forgot to pay the IRS. Let's not do that. So first, know what you've got, then pay your bills with it, and then once all of that is settled out, then you're good. I'm watching my time here, so we're getting close, but we're good. So you've got all of your debts paid. Now, along the lines here, the other thing, I kind of skipped ahead. So along the lines here, the other thing that you've had to do with the court is file, after you've had your 90-day creditor period. In 90 days, you're also going to need to file an inventory. What's an inventory? First, let's start with what it is not. It is not that this person had 10 shirts, 5 pairs of pants, 2,500 pairs of shoes, and a bunch of no. Don't worry about that. People stress so much about that. It's like, no, we're going to stick a number on it and roll. That's not where you're going to have to spend your time and your energy. What the inventory is, what the court cares about, is what was the date of death value of that bank account that was just in that person's name. The date of death value of that brokerage account just in that person's name. What was the value of the vehicle? We're going to establish the date of death values of those assets that sit squarely in the estate, okay? That's what your inventory is for. Now, on that inventory, now I'm going to muddy the waters just a little, kind of because we have a little time, but just in the sake of completeness. One thing that I will acknowledge is, I said a typically earlier, and you probably didn't catch it, and that's fine. Those assets that were just owned by the decedent, they're squarely in the estate. They're subject to pay the debts. Assets like beneficiary designated retirement accounts, life insurance, all of that stuff passes outside of the estate, not subject to the estate. There is a little gray area, and that's in your joint accounts. So, remember those joint accounts that you had with survivorship that you could go ahead and move to the survivor? Those joint accounts, if we talked about paying the debts of the estate, let's say the debts of the estate aren't enough. But let's say there was a joint account sitting there with another individual. Then let's say if it's with one person, up to half of that account can be pulled back into the estate to pay the claims of the estate. I say that more not to get into it because you have to make the note, and I got to remember this. More just to say it's just another reason why you want to keep your powder dry for a little bit. And before you start going paying a lot of things and moving a lot of things, let's first know what you've got to deal with, because you may end up needing to pull a little bit of that money back to pay some other things, okay? But let's say you've gotten clear of all of that. You've gotten the estate open. You've identified your debts. You've identified your assets. You've run your notice to creditors. That's now done. You filed your inventory. Everything's done. Everything's in their nice little place. Now what do? We get rid of it. We make those distributions to either the beneficiaries under the will or to the intestate without a will, those statutory beneficiaries. As the executor, you don't get to play favorites. You don't get to say, you know what, I never liked him. And I don't think she meant to do that. Surely not. So I'm going to do a little bit something different. Yeah. I was just asked this yesterday. That's why I bring it up, because this comes up a good bit. When there's a will, you don't get to change it. That's also good to know when you have a will. They don't get to change it. As the executor, you have to distribute those assets the way that will said, or the way the statute said. And when you make those distributions, those beneficiaries are going to actually need to sign a receipt saying, I got what I was entitled to receive, because the court's not going to bless the administration without all those beneficiaries saying, I'm good. This is what I was supposed to receive, and I'm good with it, and I received it. I will say along those lines, yes, are there times in which the beneficiaries all look at each other and say, we want to do something different? Are there times that there might be other situations? Yes, and there's things called family settlement agreements, other things that we can do, but the general rule, and that's with the consent of everybody if they want to do something different. The general rule is, as administrator, executor, they're carrying out that person's wishes. They're getting back those receipts, and then we're filing our final account with the court. Other thing that we have to do, and I know that there is an accountant in here, and I've left this out, is we also want to make sure that our final taxes are filed before I get there. So your final regular individual income tax return, let's make sure that gets filed. If there's enough income in an estate, you may need to file an estate income tax return. Just like if you generate enough income, you got to file a tax return. If an estate generates enough, then they've got to file a tax return. There may be a need, again, as I said earlier, unlikely, but maybe, for an estate tax return. Now, estate taxes, that currently only affects estates that are greater than $13.99 million. In 2026, that goes to $15 million, and it keeps in its index. It moves up. So chances are you're not going to have to worry about that one. But just so you know, because it's not too long ago that number was much less. And by the time that you had a house and a car, maybe a retirement plan, you were dealing with estate taxes. So it's not that far in folks' memory that that was a very viable thing you had to deal with. But those numbers have really shot up to the point where now it's very rare that we have to deal with it. But we want to make sure those taxes, those returns are filed, that if there's taxes that they're due, that those get paid. And yes, we want to make sure if there is a refund that is due, that it is received before we close the estate. And I will tell you that that can take time. I have a lot of estates right now that are, we've done everything. It's done. We've actually largely made some distributions from the estate. All we're doing is we're waiting to get that check from the IRS or Department of Revenue. So I'll go ahead and tell you, get that done. And just know if there's a refund due, it may take a while. But once everything's in, what we're going to do is we're going to file that final accounting with the court. That's it. That's your last step. And when you file that final accounting, all that does is it takes what did you have as of date of death, that inventory number that we established. What came in? Were there refunds? Were there was there a premium refund or a final payment from something that came in? That gets what came in. What got paid? What bills got paid? And then what were the distributions that were made? And then we want to show at the bottom of that a zero balance. Everything's done. Submit that with the court. The court audits it. If they need any more documentation, they'll let you know. And then they'll bless it and say, you're done. You're discharged. You're out. No more. And then that's it. You're done. Your job is over. But it's a good reason why you want to make sure everything's done, because you want to get that discharge. You want to get that blessed final accounting from the court. And so then the paperwork's done. I know the grief's not done. I know the feeling of that loss of that person is not done. But the work of it is done. I have run my mouth a lot for the last 55 minutes. And I promised Q&A, and I also know that we were going to try to keep this to an hour. I will say this, however, I am here for as long as you need me to be here. So I've talked about a lot of after-death things. I did have some folks mention to me beforehand they had questions about powers of attorney. I will say briefly, powers of attorney are important. Today we talked about a will. Powers of attorney are important. We're talking about during your lifetime. What happens if you need someone to step in and pay your bills or deal with people on your behalf, like credit card companies, or dealing with a car, trying to handle things for you? Then having that general power of attorney in place is great, to have that person who can run around and do those things for you, either if you simply can't because mentally you're not able to do it anymore, or physically. You say, look, I'm good. I want to sit right here, and if you could just go handle this for me, then that's great. So we can do a general power of attorney for that. Likewise, healthcare powers of attorney. If you do get to the place where you can't make your own healthcare decisions, having somebody in that role, those are important documents to have. And then the other thing, that this can be a whole other thing, so I did not go into it. Everything that I talked to you about as far as probate, there is a way to avoid it. And that is what's called a revocable trust, a living trust. That is a whole other separate topic for another day. The general rule of thumb, everything I said to you about those assets that are just in someone's name and don't have anywhere else to go, if we start getting those assets and get all of those kinds of assets that are just in someone's name into a trust, and everything else is either jointly owned or beneficiary designated, that's a way we can avoid the last 55 minutes of conversation. But that's a whole longer description to that. Questions? Yes. Yeah, well, yes. So the executor is entitled to a fee unless the will states otherwise. Then what typically you get is, under statute, that the person is entitled to receive up to 5% of the total receipts of the estate, so the assets in the estate, eligible disbursements, that's most of the disbursements. They add those together, and then they say up to 5% of that the court can award in the court's discretion. The court generally awards 3.5 up to 5%. They can award more. Or I've had wills say, no, I want to fix it, and I want to say what that person gets. Yes.
This is the real easy question. Keep talking about the court. For us foreigners, where is the court? Which court?
Okay, yes. And actually, you didn't know it. But that's a trick question because you're sitting in Guilford County. Guilford County is the only county in North Carolina that has 2 courthouses. We have a courthouse in High Point, and we have a courthouse in Greensboro. They do the same thing. There's just one's local to High Point, one's local to Greensboro. But one's downtown High Point and downtown Greensboro. There is no magic to it. You can file in either one. We do tend to file in High Point because we are here. But you could file in Greensboro. Yes.
Let me bring you the microphone. We're recording this.
Is there a number of days after someone dies that you have to let Social Security know?
So here's the fun part about Social Security. Well, there's a lot of fun parts about Social Security, but the funeral home is actually who lets Social Security know that you've passed away. So that's who tells Social Security. You can always reach out to them and let them know, but it's going to be the funeral home who does. The fun thing about Social Security, and you may or may not already know this, but when you're receiving your monthly payments, it is based upon your surviving the entirety of a month. So let's say that you get your payment in early August. That is based upon your having survived all of July. So here's a good example. Right now, let's say somebody were to pass away today, and we're here on the 29th of July. Most likely, that August payment's going to hit because the person died too late for them to stop the roll. But they're not entitled to it because they didn't survive all of July. So what will happen is you're going to see that Social Security payment come in. Give it a day. You're going to see it move then right back out under cover of darkness. They will know, have been told that you passed away. So if you see it come in, just let it sit because give it a day or two, it'll come right back out.
Okay. And my second question is, okay, if I decide this is way too much for me to handle and I want an attorney like yourself to do it,
Yes.
is there a normal percentage that, or what would be the fees or the normal range?
There was a time in which it was common practice to charge a percentage of the estate. That's largely not done anymore. Usually because you may have a smaller estate that entails a ton of work, and so that percentage may be too low. You may have a very large estate that's pretty simple, and then you're really overpaying that attorney. So what most attorneys do now is charge by the hour. And so in my case, I'll charge my hourly fee. I also have a gem of a paralegal. Estate administration paralegals are absolute wonder children. And so she charges less than I do, but she knows what she's doing. And so what we would do is we would talk if we were to open up an estate. I can look and kind of see what needs to be done, and then I could give you a range of what it would cost. Going back to payment of claims, remember, attorney's fees stand in that top group of costs of the administration. So that might, hey, funeral home does too. So we both did well before the court. But that does not, so in other words, we're not going to expect you to come out of pocket. I mean, unless there's absolutely nothing in the estate, but usually then you're not having to do an estate. So, but usually that would get paid out of the estate. Yes.
I don't know who you pointed to.
This gentleman right here. I'm kind of backing out.
If I understand you, if I have no real property and everything else with my wife and I are held in a joint with right of survivorship, then I wouldn't need to go to probate?
Very likely no. Yeah, if there's no real property, or even if there is real property, and I didn't really talk a lot about real property, but if you own real property, let's say with your spouse, and so it's me and spouse so and so, that was terrible grammar. But that would mean that upon the death of the first of you, it automatically goes to the surviving owner. It's that same survivorship feature. But yes, there's a very good chance that upon the death of the first of you, then if everything's with survivorship or has a beneficiary designated, or if there's no real property, then you may not have to do anything.
And the same would hold true with a surviving spouse and one child if they put the child on as a,
Yes, if there was one, yes, if there was one child, just be careful about that. If there was one child and then the surviving spouse then put that one child on everything or designated everything, then yes. Just always be careful though, because then remember, you're making your assets, or that surviving spouse is making their assets then subject to the debts of that child. Again, casting no aspersions on them, but if let's say they're in a bad car accident or something like that, life happens, then I'm always mindful of that, because that could be a problem. But yes, technically your answer is absolutely right. Yes.
Does the estate tax exemption roll over to the surviving spouse?
Yes. The estate tax is actually there's what's called portability. So but mind you, that does have to be elected by the surviving spouse. There's filing a form or filing a return in which you mark and you elect the portability to take what that spouse has either in its entirety or their unused portion, and you port it over to the surviving spouse. Yes.
Okay, first I have a comment about, you mentioned death certificates.
Yes.
As you're handling things, ask, is the original death certificate necessary, or is a copy good enough?
Exactly.
Because you have to pay if you need more death certificates.
Absolutely. And a lot of places, she's exactly right. Lots of places, they may want to see the original, but a lot of times they're just fine then making a copy of it and giving the original back to you. The one that I know we're going to keep the original, it's a common theme, is the DMV.
And my question is, when I did my will, my lawyer talked me into like doing a trust. I still don't understand the difference between a will and a trust.
That is an excellent question with a really long answer. And I may need to talk to you more about that, or maybe even do another one of these things. But the general idea is this: a will is what we just talked about, is the probate process, is taking those assets that didn't have anywhere else to go, joint owner, beneficiary, and then saying where those assets go. I'm doing a 30,000-foot thumbnail view, but I want to answer that question because it is important and it is good. And there's a lot of people out there going, but what about trusts? The idea of a trust is this. Let's say on that bank account, instead of saying Sue Smith, let's say that bank account was held in the Sue Smith Revocable Trust. Let's say her car was held in the Sue Smith Revocable Trust. All of the assets that instead of being in that person's sole name were instead held in the trust. When you look at a trust, if you get basically past the first page or so, that trust is going to start reading a lot like will. Because the trust is going to say, well, during my lifetime, I've moved all my assets into this trust. And that's where things fall through. But you got to make sure everything is in that trust or beneficiary designated. But if you get all of those assets into the trust, and so now they're under the trust umbrella, you use them during your lifetime, just like you do right now. But then it says, but when I pass away, these assets go to this person and this person and this percentage, and it's just like a will. Because it says who gets what. After everything we just talked about, that's how it plays out under a trust. But the key part is this. Because those assets are already sitting in that mechanism, in that trust that says where they need to go next, then you don't need to worry about that probate process because it has somewhere else to go. You've put your house in it, you've put your car in it, you've put your bank accounts in it. And so that trust then says, upon my death, this is where these assets go. And so since they've got somewhere else to go now, the court doesn't have to be involved. And so there's not a need for probate. The key, where I see it not work so often, is you go see an attorney. They say, oh, you need a trust. And they give you a big, pretty binder with a trust and all this other stuff. And that's great, but that's like step one. Because what has to happen, the pretty binder and the pretty pieces of paper mean nothing if all those assets don't then get put into the trust. You don't go to Pinnacle, First Bank, First Citizens, move those bank accounts into the trust. You don't go and move your car into the trust or take your brokerage account and move it into the trust. Because the trust is a pretty piece of paper, but until you actually put the assets into it, it doesn't control them. So that's the key part. Trust and will, they both talk about what happens after you pass away. But the trust can only do that if it actually has control over those assets.
I have another question. Like if I change bank accounts, I have to change my trust?
You don't have to change your trust. You just have to make sure that new bank account is titled into the name of your trust. The language of the trust is usually going to use more general language. It's going to talk about real property, land, buildings. It's going to talk about personal property, bank accounts. It's not going to talk about specific accounts. So you don't typically, if you change bank accounts, you don't typically need to change the terms of the trust. The trust is still going to apply to it. The key part is making sure that you first get all of your assets into the trust, and then as you may get new assets, you always remember, you kind of keep that trust hat on, and you always remember that any new assets need to go into the trust. Yes,
If one has a will or a trust in place,
yes.
is there a time period that you advocate that one officially reviews that document, and should it be done with one's attorney?
So, for good rule of thumb, every 5 years, or when there's any significant life change, somebody's passed away, or some other significant change of circumstances, I would advise pulling it out and reviewing it. As far as reviewing it with your attorney, I think that's probably a good thing to do. You certainly can look at it yourself and maybe pick up whether or not there's been any changes. But it's also good to check with attorneys too, because we may know that there's been another change in law or something else that we need to advise you of. In 2018, for example, our statutes for powers of attorney have a complete overhaul. And so it doesn't mean if you have a power of attorney, that was before 2018, as long as it was valid then, it is valid now, okay? Don't freak out. But when they did do the new powers of attorney, and as we're updating documents, so let's say someone's come in and they want to update their will, but if they did their power of attorney before 2018, then I want to update that power of attorney. Because even though the old one is still valid, now it's got some age on it. Now over 7 years, new statutes, people are getting more used to new forms. So that's a good example of why it's good just to go touch base with your attorney. They may know something that they also would like to update, not just to generate a fee, but something that would make sense because it would make it better for you. Yes?
My attorney recently explained to me how their electronic filing system was such a wonderful thing, and I've done several in my past, and it was a long, drawn-out, process. And with the state of the License Bureau, I don't intend to stand in line forever to do anything. Can my attorney do it electronically, whatever needs to be done with DMV?
Unfortunately, no. Unfortunately, we can't because That person, the only person who would be able to do that with DMV is, I mean, we can mail things in for you. I will say that, yes, we can mail things in for you. And I used to do a lot more of that as part of my practice than I do now. It got to the point of ridiculosity of you would send something and they would send it back to you because that day they decided they didn't like the color green. The most ridiculous example, and the reason why I tell people to go to the DMV, and I will give you this just for laughs, okay, is if you've ever looked at the back of a title, and there's these 3 sections generally, and the top section is where you usually have your buyer and seller, and that has to be notarized. And the notary stamp, there's a line, the notary stamp here scooted into the little bottom of the little arc, scooted into section B. And it was sent back and it was said, the document was executed in section B and this is wrong. So it's that kind of stuff that will drive you mad. And so that's why I actually tell people, just go ahead and deal with the DMV, because sitting there in their office, it's going to eliminate that kind of back and forth, because it really got to the point that it was silly. Well, let me be clear about something. 2 different things. DMV, as far as getting your license renewed, and the tag agency, where largely this is being done. That's not nearly the weight at the tag agency as DMV and getting your license renewed. Yes, you might be sitting there an hour. You're not sitting there all day and then getting to the end of the day and then being told, sorry, we're done for the day. Yes.
We redid our wills right before we moved to River Landing, and we designated certain gifts to individuals and charities. Well, we've changed our mind since then. Do we need to do entire new wills, or can we do codicils to change?
Yes. And I don't mean that to be like super cheeky. A codicil is what a codicil is. A codicil is a fancy term for an amendment to a will. And so, yes. And historically, we did codicils because we didn't want to have to retype an entirety of a will. And so it made a lot more sense and was a lot more financially prudent to take in just one section and execute a codicil. Yes, you can do that. But I would say be very careful, because you can easily execute one and then it has the effect on some other provisions. So you want to be careful that you catch all of those. I tell folks now, especially now with word processing, using Word, by the time I have done a codicil to somebody's will, I probably could have done a fresh new will anyway. And it probably wouldn't have been much of a difference in a price. And then you've got because the other fear is this: they find the will, but they don't find the codicil to the will. And so then all of a sudden you're going down one way, they don't know there's a codicil, or they get halfway through and realize, uh-oh. So I think especially now, it made sense back when we were having to type everything out, absolutely, codicils all day. But now I think just doing a fresh new will is actually probably just as easy and really financially not that different. Yes.
Can you speak briefly about inventorying high-value collectibles, artwork, that kind of thing? And if it's a spousal situation and you've bought those things together, don't they just belong to the spouse?
So, yes. So a lot of times we usually do not worry about getting appraisals for tangible personal property. Let's start with that as a general rule. We usually don't worry about that because for the court's purposes, they don't care. And I'll just be blunt. The court doesn't really care about those kinds of things. they see tangible personal property, we stick some sort of nominal value, $250, $500 on it. They say that sounds great, and they move on. The only, if there's, if we're talking about Picassos and, Cezannes and things of that nature, and to the degree that there's a need for tax purposes or something like that, maybe, but usually in an estate, we usually don't worry about getting appraisals. Now, I want to change something here. Real property. Let's talk about that real quick, because I have a different opinion about real property. When you own, especially when it's not owned between husband and wife, especially when it's now only owned by one person, you may very well want to go ahead and get an appraisal on real property for tax purposes. Because especially if you bought a house back in the 50s and 60s, and you bought it for $35,000, $50,000, but now it's clearly worth a lot more than that, and it's likely worth more like $250,000, $300,000, then it may make a lot of good financial sense to get that real property appraised, because then when the beneficiaries go to sell it for capital gains purposes, when they talk about what their basis is, they get what's called step up. They get what the basis is as of date of death, but they won't know what that is. And the best way to establish it is to go ahead and get it appraised, so that you've got that number that they can rely on for tax purposes. And that's the thumbnail sketch of basis, and it's not really a good one at that. But I would advise for those purposes, for real property especially, is to get it appraised, because you're going to get that step up in basis for, you're not going to have to pay the increase on what they bought it for back in the 50s if you're inheriting it, but you want to establish what that value is so that they know what it is. Yes.
So we've got one more back here, and then we'll, or do we have another one over there that I missed?
I've seen other hands, but I
Okay.
may have answered.
So
And
we'll
one right here too.
Okay, we'll do a couple more, and then we'll let Leanne finish. You have been amazing. Thank you
glad
so
to
much.
help.
So here we go.
You're welcome. Well,
If you have non-traditional funeral arrangements, such as donating your body to medical science or a green funeral without a funeral home, can you get the death certificates and all that? How do you get that?
so for that, I would arrange it. If you've been under hospice care, or if you've been under hospice care, they can help out with that. If you're at a facility, they can help out with obtaining that. Some of those facilities can still help you. Some places who do like the green burials, they can still help you with things like that. So there's different ways to get that death certificate, because the person who is declared death is going to be the one who has to report it to the state. So reaching out to a care facility or to hospice or things like that, they'll be able to get it for you. Well, the person, if it's hospice, they're going to report it. If you were to die here at River Landing, they're going to have to report it. That's going to be their obligation. Well, for example, if you were here at River Landing, or if you were at the hospital, they're going to have reporting requirements, so they're going to have to do that. But one thing to tell you as a follow-up on that, if you have those desires, a lot of times people want to put those in a will. Don't put it in your will. By the time the will services, those decisions have been made, and it's a little too late then. So what I would do in your healthcare power of attorney, powers of attorney are good during your lifetime, and for almost every purpose, they stop to have an effect, except the person who's acting as your agent under healthcare power of attorney has the authority to make decisions regarding green burial, cremation, all of those kinds of things. So that's exactly where you want to have that language, because that's going to be the person who can carry out those wishes So put that in there so they know this is really what I want.
I'd like to know why you don't have to put your IRAs into your trust.
So your IRAs, because they're retirement accounts, you're not going to change that because you as the retiree or whatever, or the owner of that account, you will still remain the individual owner, okay? But for tax purposes, the way those are set up, you will still individually be the owner. But what you want to do is to make sure your beneficiary designations then dovetail with what your estate plan is. And that will be just as efficient as long as you've made sure that that beneficiary designation doesn't change. But yes, technically you don't change it because the way that as being a retirement plan, you're always going to remain individually the owner.
All right. Can y'all help me say thank you? That was amazing. Thank you so much.
Thank you. Really enjoyed it. Thanks so much. Great questions. And if you have any other questions, let me know. I'll hang around here if you've got other questions. And hope you have a great rest of your day. Oh, good.